want you to picture the year 1983. You're walking into a video arcade, the golden era. The air is thick with the smell of cheap pizza and ozone. That crazy, vibrant, geometric carpet is under your feet. And the room is just this chaotic symphony of beeps and bloops and synthesized music. Video arcades are absolutely booming at this point. They are printing money literally. But while millions of quarters are dropping into those machines, there is a massive legal brawl brewing behind the scenes. And it involves a cast of characters you would never expect. On one side, you have an established Hollywood titan, Universal Studios. And on the other side, you have this underdog Japanese company that was founded way back in 1889 making playing cards, but is now making massive waves with a brand new arcade game. That company is Nintendo, and the game, of course, is Donkey Kong. It's the ultimate David versus Goliath story played out in federal court. Universal is claiming that Nintendo's smash hit game is blatantly infringing on their trademark for the legendary cinematic giant, King Kong. But here's what most people don't know. Nintendo wasn't the only company caught in Universal's crosshairs. Before Universal ever stepped foot in a courtroom against Nintendo, they had already quietly shaken down another company for millions of dollars, a company called Coleco.
You like Donkey Kong, eh? Okay, big fella.
And that secret shakedown is a huge part of why this story matters. We're gonna unpack all of this here today. I have actual court transcripts, internal Hollywood studio memos, desperate business letters, and the paper trail from a secret settlement that cost one company $4.5 million. And by the end, you're gonna see how a single legal bluff nearly reshaped the entire video game industry. But first, let me set the stage properly, because before Universal ever sent a threatening letter, there was a toy company that saw an opportunity and walked right into a trap. In 1982, Donkey Kong isn't just a popular arcade game, it's a cultural phenomenon, and the toy maker Coleco sees a massive opportunity. They secure the highly lucrative rights from Nintendo to port the arcade hit into living rooms on ColecoVision. This is a big deal. Coleco is betting a huge chunk of their business on bringing Donkey Kong to home consoles. But over in Hollywood, Universal Studios president Sidney Sheinberg is watching. He sees Coleco's aggressive marketing campaign, recognizes a giant ape standing on top of a building, and decides Universal is owed a cut. So Universal fires off aggressive cease and desist telexes to both Coleco and Nintendo. They claim absolute trademark ownership of the King Kong name and character, and they demand all profits generated by Donkey Kong. Now, here's where the two companies take dramatically different paths. Coleco panics. They are terrified that a lawsuit will destroy their impending console launch. They can't afford to sit in federal court while their product window closes, so they quietly fold. They sign a secret agreement agreeing to pay Universal a 3% royalty on all Donkey Kong game sales. And that fear came with a massive price tag. Coleco ultimately handed over more than $4.5 million to make the problem go away. Nintendo? They took a completely different approach. They refused to pay a single dime. Instead, they did something nobody expected. They asked Universal for a legal chain of title, paperwork, actual documentation proving that Universal owned the exclusive rights to the giant ape. And Universal arrogantly brushes them off. Their lawyers refuse to produce the documents, telling Nintendo's representatives that the copyright infringement was simply an open and shut case. That refusal to provide basic proof, that tipped Nintendo off.
Here we go.
Rather than backing down, Nintendo's lawyers started digging into the legal history of King Kong, and what they found blew the entire case wide open. But we'll get to that, because before we go any further, we need to define the battlefield, and this is important. We're not talking about copyright here. Universal is suing over trademark, and the difference between these two things is the most important distinction to make right out of the gate. Okay, so copyright versus trademark. Copyright protects the actual creative work, the specific script, the literal footage of the 1933 King Kong movie. That's copyright. I can't take someone's literal footage and upload it to my YouTube channel. That would be a copyright violation. But trademark law does something entirely different. A trademark is a source identifier. It's fundamentally a consumer protection mechanism. It exists so that when you buy a product with a specific logo or name on it, you know exactly who made it. So let's take the Nike swoosh logo. If I make a shoe and I put that Nike swoosh logo on there, I am now in trademark violation because someone could buy that shoe thinking they're buying it from Nike, meanwhile they're buying it from me. So back to the case, think of it this way. If I draw a cartoon of an ape on a building, am I stealing a brand or am I just using a universally understood trope? That is the question at the center of this entire case. Universal wasn't claiming Nintendo literally copied the film's footage. They couldn't. It's a pixelated game. What they were claiming was that Nintendo was using the King Kong brand identifier to trick consumers into thinking Universal was somehow behind Donkey Kong. And that brings us into the actual courtroom, because I was reading through the 1983 court transcript between Universal's attorney, a man named Douglas Fairhurst, and Judge Robert Sweet. And the way Fairhurst argues this case is fascinating. He tells the judge that a trademark is a merchandising shortcut, what he calls a congenial symbol that draws people in. He explicitly says, and I'm quoting from the transcript here, "This is not a case involving toothpaste or boxes of soap. Because when you buy soap, the trademark guarantees the physical manufacturer. But with entertainment," Fairhurst argues, "that the owner exploits a human propensity by, in his words, impregnating the market with the drawing power of a congenial symbol." A congenial symbol. Let that phrase sit with you for a second. What he's claiming is that Nintendo deliberately used the King Kong idea, specifically the combination of the gorilla, the fair maiden, and the building, to artificially generate sales for their game. He argues that people are not drawn to Donkey Kong because they love Nintendo's programming. They're drawn to it because, in his words, it is Kong. But Judge Sweet immediately pushes back on that logic. The judge looks at this and calls King Kong ideational. Concept, a story, an idea. And the judge is asking a question that cuts right to the heart of this case. At what point does an idea become so famous that it just belongs to the public? This is exactly where Fairhurst's argument hits a wall. He is essentially trying to use trademark law to legally fence off a genre, an atmosphere. You can't trademark a plot device. And under intense pressure from the judge, Fairhurst is actually forced to make a crucial admission on the record. He concedes that if Donkey Kong didn't feature both the ape and the building together, Universal would have a much rougher case. Because an ape alone is just an ape in a jungle. A building alone is just architecture. But an ape on a building, that is the specific combination where Universal starts shouting about infringement. Now, if Universal is so desperate to protect King Kong as this vital, exclusive brand, there's a natural question: how did they even get the rights in the first place? Because Universal did not make King Kong. And the answer is a total mess. When we open up the internal MCA and Universal memos from 1980, the paper trail is incredibly chaotic. It is a completely tangled web of Hollywood rights. To understand why Universal went after Nintendo, you have to look at an agreement from December 15th, 1976. Richard Cooper, who was the son and heir of King Kong's original creator, Marion C. Cooper, transferred certain rights to Universal for $200,000. Just $200K for King Kong. And this only happened after a very complex legal victory where Cooper won those underlying rights back from RKO General. RKO! Which was the studio that originally produced the 1933 King Kong film. But here is the critical backstory. To understand why those rights were even available, you have to go back one more year to 1975. Universal had desperately wanted to produce their own remake of the classic 1933 King Kong movie. But RKO had already licensed the remake rights to another producer, a guy named Dino De Laurentiis. Blocked from making their film, Universal executed an aggressive legal maneuver. They sued RKO in federal court. And they won, but not in the way you might think. Universal successfully argued that the original King Kong story was actually in the public domain, available for anyone to use. Remember that. It becomes enormously important later. The judge's 1975 ruling created a chaotic aftermath. The intellectual property rights to King Kong were completely fractured. RKO kept the visual rights to the 1933 movie. Dino De Laurentiis and Paramount held the rights to the 1976 remake, and Richard Cooper was awarded the underlying book and character rights. Universal then quietly purchased those specific narrow rights, book and character, from the Cooper estate for that $200,000. So, Universal buys those rights in 1976, but the internal memos, specifically documents written by a senior Universal staff attorney named Joseph DeMuro, show they did not do anything with those rights for years. Nothing at all. They just sat on them until 1980. Now you might be thinking, Universal paid good money for this property. If you buy a house, you own the house, whether you move in immediately or 5 years later. So why does it matter that they sat on the rights? Well, because intellectual property, specifically trademark, does not work like real estate. A trademark is a use it or lose it proposition. As we already established earlier, a trademark is an active identifier of a source. If you're not actively using it in commerce to identify your goods, you are no longer a source, and it ceases to function as a trademark. And the DeMuro memos from June 1980 lay out exactly why Universal was paralyzed. Even though they bought the rights from Cooper in 1976, RKO had already granted exclusive merchandising licenses to Dino De Laurentiis and Paramount for their 1976 King Kong movie remake. DeMuro's legal opinion confirmed that Universal was completely blocked from doing any of their own King Kong merchandising until those pre-existing licenses expired toward the end of 1979. They were entirely trapped by old contracts. But it gets worse. The internal paper trail that came out during discovery in the Nintendo lawsuit revealed something stunning. Universal's own attorney, DeMuro, had previously circulated an internal memo warning executives that rival studio RKO still owned the visual representation of the King Kong ape, not Universal, RKO. This anxiety over visual rights led to bizarre internal policies. Universal issued a strict set of King Kong guidelines to their own theme park designers. Rule number 1 expressly forbade personnel from even screening the 1933 or 1976 King Kong films. They couldn't even watch them. Rule number 2 went even further. It directed Universal staff to design generic apes or use reference photos of zoo animals specifically to avoid getting sued for copyright infringement of King Kong by RKO. Think about that. Universal was telling its own employees not to look at King Kong because they knew they didn't own the visual rights. And at the exact same time, they were threatening Nintendo with lawsuits for allegedly copying that same visual identity. They were fully aware they had no legal right to the very visual trademark they were accusing Nintendo of stealing. But the moment those old merchandising licenses expired, Universal went on an absolute rampage. In July 1980, DeMuro fires off incredibly aggressive letters to Paramount, to Dino De Laurentiis, and to RKO, formally warning them that their time is up and Universal is taking over all merchandising exploitation. They needed to establish a paper trail of aggressive enforcement. They were sending these letters and claiming control over every single image of a giant ape to retroactively build up the strength of their trademark. And the source documents show them throwing their weight around in the strangest places, like they actively licensed King Kong for a Halloween costume made by Ben Cooper Inc., which was basically just carrying over an old Paramount license. And they even went after Continental Airlines. Continental wanted to use a poster featuring a still of King Kong on the Empire State Building with the slogan, "You can't fly any closer to New York," which sounds like a great ad, right? But Universal's legal department immediately flagged it, stating Continental needed Universal's permission because it involved a merchandising right that they now controlled. It's incredibly brazen. They are actively trying to retroactively claim absolute control over a cultural icon using rights they had barely exercised. They needed to prove to the world and eventually to a federal judge that King Kong was a tightly controlled, exclusive identifier of Universal Studios, which, as you might have guessed, did not go so well. You see, their aggressive enforcement strategy completely backfired when they aimed it at Nintendo. And I have to say, Nintendo's defense is one of the most brilliant legal maneuvers I have ever seen. Remember, when Universal first sent those cease and desist letters, Nintendo did not panic like Coleco. They asked for proof. And when Universal arrogantly refused to provide a chain of title, Nintendo's lawyers went digging, and they struck gold. They found the trail leading back to that 1975 lawsuit, the one where Universal had sued RKO, the one where Universal had successfully argued that the original King Kong story was in the public domain, available for anyone to use. Nintendo's lawyers now have the receipts. But they didn't stop there, because the legal strategy Nintendo deployed goes beyond just poking holes in Universal's ownership claim. They attacked the very foundation of Universal's trademark by arguing that the term King Kong had been completely diluted by, as they phrased it, innumerable published and commercial uses. This connects to the bigger picture of something called trademark genericization. Think about everyday words like escalator or aspirin or thermos. Those all started as specific brand names owned by specific companies. But because the public started using those words to describe the thing rather than the brand that made the thing, the companies lost their trademarks. The courts ruled that you cannot have a monopoly on everyday language. So Nintendo's lawyers essentially walked into court carrying a stack of dictionaries, and the dictionary citations they used are absolutely incredible. They cite the Oxford English Dictionary, which formally defined King Kong as a common term used as a nickname for anyone of outstanding size or strength. Funny enough on its own. But also, crucially, it defined it as a slang term for cheap alcohol. And it doesn't stop there. They quote the Dictionary of American Slang, which defines King Kong as strong, cheap whiskey or wine. And then they open up Roget's Thesaurus, which lists King Kong simply as a noun synonymous with terms like monster, fiend, or brute. So Nintendo's lawyers are essentially telling the court, you do not own a famous movie monster. You own the dictionary definition of bottom shelf booze. And that destroys Universal's entire argument. Remember, a trademark's only job is consumer protection, to define a specific single source of origin so consumers, you and I, are not confused when buying something. But when a term becomes so widely used that it enters the everyday lexicon as a generic description for a large brute or slang for cheap whiskey, it completely loses its power to point back to Universal Studios. If a consumer hears King Kong and thinks bottom shelf booze, they are not being tricked into thinking Universal made Donkey Kong. The trademark evaporates. It's the ultimate judo move. Universal says King Kong is so famous it is our exclusive property. And Nintendo flips it and says no, King Kong is so famous it belongs to the English language. Nintendo also pointed out that there were numerous third-party trademark registrations for the name King Kong and commercial uses of the graphic image of the ape that had absolutely nothing to do with Universal. Universal simply could not claim that the name uniquely identified their products when there were all these other businesses already using it. Now, what does summary judgment mean here? It means Nintendo is telling the judge, this case is such a joke, it should not even go to full trial. Even if everything Universal says happened actually happened, they still don't have a valid legal claim, so end this now. And as part of that motion, Nintendo filed a Rule 3G statement, which is a specific procedural document where you list all the material facts of the case that you believe are completely undisputed. Nintendo's Rule 3G was a masterclass in legal demolition. But here is maybe the most damning detail in this entire story. And seriously, when I found this, I couldn't believe it. Remember that 1975 lawsuit? The one where Universal sued RKO and successfully argued that the original King Kong story was in the public domain? The Universal lawyer who aggressively threatened Nintendo over trademark infringement in 1982, was the exact same lawyer who had successfully proved King Kong could not be trademarked in that 1975 lawsuit. It's the same person. Standing in court in 1975 saying King Kong is public domain, anyone can use it, then turning around 7 years later and telling Nintendo, King Kong is our exclusive property, pay up or else. You cannot make this stuff up. Now, while these highly paid attorneys are having this fascinating intellectual debate about slang and giant apes, actual businesses on the ground are bleeding money. And this is the dark side of this story that doesn't get talked about enough. See, if you run a small business, I have a document from January 6, 1984 that is going to give you heartburn because it proves that in the business world, you do not have to lose a lawsuit to be destroyed by one. It's a letter from Thomas Guggenheim, the president of a company called Hosiery Mills, writing to the licensing manager at Nintendo of America. Hosiery Mills was a company trying to sell Donkey Kong merchandise, socks, apparel, that sort of thing. But Universal had not just sued Nintendo. They had been blanketing the market with cease and desist letters to Nintendo's licensees, threatening them with litigation if they kept selling Donkey Kong products. And Guggenheim's letter is painful to read. He tells Nintendo that the agreements offering to indemnify his company, basically Nintendo promising to cover their legal costs if Universal were to sue them, were arriving too late after the fact. He writes that Universal has threatened them with lawsuits and had a crippling effect on their ability to meet their sales guarantees. And he makes a point that is foundational to the arcade and toy business. Timing is everything in sales. Arcade games are a fad-driven market. Retailers do not want to stock a product if they think they might get dragged into federal court by a Hollywood studio. Who has that kind of money to fight them? Nobody. So by the time Nintendo was able to offer indemnification and reassure those potential customers that the legal threats were baseless, the momentum was completely lost. Guggenheim explicitly says his potential customers had been temporarily scared off. And now, in 1984, the chances of selling much more of the merchandise are quite remote. The window had been closed. This brings up a brutal reality about corporate leverage. In their plaintiff's memorandum, Nintendo accuses Universal of tortious interference, which basically means Universal was illegally interfering with Nintendo's business relationships to cause them financial harm. But Universal defends themselves by invoking the concept of probable cause. They argue that they had a legal right to issue those threats because they were acting in good faith based upon the advice of their attorneys. Now, let me make sure you understand that mechanism. Universal is essentially saying, our lawyers told us we own King Kong, so we had probable cause to believe we were right. Therefore, we had every right to send those scary letters to hosiery companies and toy makers, even if we eventually lost the case. It's a remarkably effective shield, and it highlights a massive reality in the business world. The tension between a corporation's legal right to vigorously protect its intellectual property and the devastating collateral damage that IP bullying inflicts on smaller partners. Because the smaller partners just fold. When a multi-billion-dollar studio sends a letter to a small hosiery mill, the mill doesn't have the resources to analyze the nuances of trademark dilution or summary judgments. They just know they can't afford a protracted legal war with Universal Studios, so they drop the product immediately. It's the absolute weaponization of the legal system. It paralyzed the Donkey Kong merchandise machine at the exact moment it should have been printing money. The confrontation finally reached its climax in a federal courtroom. Nintendo laid Universal's bluff out for the judge to see. They delivered the knockout blow by pointing out the stunning contradiction. Universal was claiming trademark ownership over a visual identity that their own internal memos proved they knew they did not own. Judge Sweet forced Universal to define their trademark, and all they could offer was a vague description of a giant gorilla holding a captive on a building. The judge ruled that without a specific identifiable image, it was unable to function as a trademark as a matter of law. And the final ruling was devastating. The court found that Universal had acted in explicit bad faith. They had deliberately extorted licensing fees while knowing they possessed no exclusive rights to the visual identity of the ape. Universal's trademark claim was completely annihilated by the judge. The court ordered them to pay massive damages to Nintendo. And there's one final detail from the appellate court transcript that frames this entire legal battle in a completely different light. You see, during the appeal, Universal's lawyer holds up a King Kong tabletop video game to prove to the court that Universal is actively using the trademark in the video game space. It was a physical electronic game licensed by Universal to a company called Tiger. But the judge asked a very simple question. When did that Tiger game actually come out? And Universal's lawyer is forced to admit on the record that the King Kong tabletop game came onto the market exactly 2 months after Nintendo's Donkey Kong had already become a massive arcade phenomenon. 2 months after. Universal was not fighting to protect King Kong's past. They were fighting because they realized Nintendo had just invented the future. But the story doesn't end with Nintendo's victory in court. Remember Coleco, the company that panicked? The one that quietly signed that secret settlement and paid Universal a 3% royalty on every Donkey Kong game sold? The company that handed over more than $4.5 million because they couldn't afford the risk of a lawsuit during their product launch window? Well, shortly after the ruling, Nintendo used the court's decision to help Coleco recover every single dollar of that $4.5 million they had been extorted into paying. Universal's bluff was not only a failure, it was just completely reversed. Nintendo's victory proved something that mattered far beyond one lawsuit. It proved that rising video game companies could stand their ground and legally dismantle traditional Hollywood titans. They established a vital legal precedent. Intellectual property in the public domain cannot be suddenly weaponized for corporate extortion. You cannot argue in one courtroom that something belongs to everyone and then walk into another courtroom 7 years later and claim it belongs exclusively to you. All right, so think about what we just walked through. A $200,000 rights purchase in 1976, years of waiting in the weeds due to overlapping contracts, an internal memo proving Universal knew they did not own what they were claiming to own, a wildly aggressive letter writing campaign that shook down Coleco for $4.5 million and terrorized small businesses just trying to sell some arcade socks, a legal defense built on dictionaries and the argument that King Kong is public domain slang for cheap whiskey, a lawyer who literally argued both sides of the same question 7 years apart, and a Tiger tabletop game that showed up 2 months too late. This is a remarkable look through the entire life cycle of a trademark dispute, revealing the immense lengths to which corporations will go to bend cultural touchstones into private property. And it really leaves you wondering how much of modern intellectual property litigation today is not actually about protecting what a massive corporation built yesterday, but simply kneecapping the competitors who are building tomorrow. Oh, and one more thing. In December 2024, Universal Studios Japan opened a brand new themed area inside Super Nintendo World. It's called Donkey Kong Country. The very ape that Universal tried to claim as their exclusive trademark, the one they sued Nintendo over, the one they shook down Coleco for millions of dollars over, is now one of the biggest attractions at Universal's own theme parks, built in a multi-$100 million partnership with Nintendo. Shigeru Miyamoto, Nintendo's legendary game designer, stood alongside Universal executives at the grand opening ceremony. Universal tried to destroy Nintendo over a giant ape in 1982. 40 years later, they are paying Nintendo to put that same ape in their theme parks, and it turns out the best way to profit from a giant gorilla was never suing over it. It was partnering with the company that actually knew what to do with one. Thanks for watching as always, guys. I appreciate your support. I'm Andru Edwards, and I will catch you in the next video.